I haven't. Did you talk all them? I couldn't really remember, but I did say they might ask questions, but sure not before hours. If you're, the Q and A, we did.
Yeah.
And it's not 3 and 3, it's 3 in his presentation. We might run it by. Yeah, we got a number of different ways on that. And whatever works for you. Yeah. And then questions? That's right. Okay. Yeah, it's so good, but I was just like, it's not that sorry. Yeah, we'll just got well, you're veterinarian, so I don't know.
still, that's very.
All rise. Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Well, welcome everyone to the afternoon session of the 10th Court of Appeals being held at MCC on their campus here in Waco, Texas. We've got one case on the afternoon docket. This morning. Thank you. This morning, I went through a introduction, explained the process, how the judges are seated by seniority, and I'm not going to go through all that this afternoon. The part of this morning that is pertinent to this afternoon is if you got one of these brochures, the second page in of the brochure, there is a court website. And it's the texascourts.gov/10th Court of Appeals or 10th COA. If you go to that website, you can sign up for something that's called case mail and follow these cases as they get further developed and decided. There won't be an announcement of a judgment today. After we leave here today, we will meet, we will talk about these cases. We will write an opinion. That opinion will be circulated. And when an opinion gets 2 votes, and everybody's had the chance, then at that point, it will be issued and a note will go out, an email to anybody that signed up for case mail so that you can follow that case. Then the other thing that's pertinent is that at the bottom of that page is a YouTube channel video address. If you go to that YouTube channel, you will see the entire session from this morning. You will see the announcements and the other things pertinent to sort of the introduction. And rather than repeat those again this afternoon, I will count on y'all being able to go to the YouTube channel and watch those if you're interested. The afternoon case, and Madam Clerk, it just occurred to me that I failed you and I failed the audience because I failed to put out the name placards for the judges from our travel box, but that's my mistake and I apologize for that. But to my right is Justice Matt Johnson, former district judge here in McLennan County. Been on the court for 3 years. And then to my left is Justice Steve Smith, who has been here for a little over 2 years now, and he was a former district judge in Brazos County. My name is Tom Gray, and I'm the chief, and I was not a district judge anywhere before I came to the Court of Appeals. So I've been here for 25 years, and the case on the docket this afternoon is Melvin Jordan versus Waco Transit. And I understand there's going to be maybe a video play during this one. And I'm assuming that, y'all talked about it, agreed upon it, no objections on that. Okay, and then, I'm ready for announcements, in the case of Jordan versus, Waco Transit.
Thank you. My name is Steve Samples. I am appearing for appellate Melvin Jordan.
Okay, thank you, counsel.
You're Alfred McKenzie and Brandon Oates for Waco Transit. And just as a reminder, the other party in the case is no longer in the case, RAT, developing SA, so at the court and expediation.
Counsel, are both of you going to argue this afternoon?
Just
Just you, okay. Because we don't allocate time, we don't track it, and Brandon, I was gonna tell you that when that happens, the second one to go always gets shorter. It happens that way, so. One thing I will explain to the audience, there's two things about the proceeding today that it's a little different when we're doing it in the academic environment. We let the lawyers talk directly to you for 3 minutes before they start their argument to us. That is not normal. If you came to our courtroom on the 4th floor of the McLennan County Courthouse and watched oral arguments, we do not let the lawyers talk to the audience during that process. We do that here so that they can place their case in a procedural explanation that allows you to understand the argument that they're going to make to us. So that's one difference. And the other is that during the preliminary process, I should have said this earlier, you could take pictures if you wanted to. We'll let some be taken at the end if you're interested in that. But normally we don't allow any photographs to be taken during the course of the proceeding, but we are streaming it on live tube, so, or on YouTube, so live, and it will be recorded and it will stay there. You'll be able to go back at any time and visit that. With that said, Mr. Samples, you may proceed with your 3 minutes when you are ready.
Thank you, Your Honor.
Wait a minute, I misspoke. I forgot that I had turned the timer completely off. I'll get that started. You may proceed when you're ready, Counsel.
Thank you. Good afternoon, everybody. Who here has heard the term frivolous lawsuit? See a bunch of hands out there. Who here has heard the term frivolous trial? See a half a hand, maybe. A lot fewer hands for this, and there's a reason for that. In the trial court down below us, that is where judges work very hard to test the merits of lawsuit. One of the things that a judge can do upon request of a party is consider granting summary judgment. The purpose of a summary judgment motion is to make sure that the allegations made in the lawsuit have some support in the evidence. And that's the burden. The judge at that point is not going to decide who would win at trial. Is that if we go ahead with trial, am I just wasting my time? Or are there facts where a reasonable jury, a reasonable juror could disagree one way or the other? Reasonable, fair-minded juror, look at the evidence. Some say it's this way, some say it's that. And that's the test. And so when the motion is filed, the motion was filed against Mr. Jordan, my burden was to come forward with some evidence in this traffic crash case. What happened? We have, in response to that, introduced evidence from Mr. Jordan that he had a green light. We introduced a report from a law enforcement officer who, after investigating the crash, talking to the witnesses, conclude that Waco Transit must have the red light. Did I say red light? My guy? My guy had a green light. He testified that way. Waco Transit was determined to have the red light by law enforcement in a report, in a supplemental report at the deposition. One of the things in the deposition, the officer was shown a dash cam. The officer said, look, I can't tell. This doesn't help anything. In the court below, I produced that evidence, And the judge didn't decide, who was going to win, just decided that that evidence was not sufficient to go to trial. And there's one judge making that decision instead of 12 jurors. So I get to go in the bonus round where 3 judges behind me here will look at the same evidence, will look with fresh eyes on a complete record and determine whether or not I should have been able to go to trial. They're not going to say who wins. They're just going to say, if they agree with me, you go back down to your trial judge, get a trial setting, and let a jury decide this. Thank you.
You may proceed with your 17 minutes when you're ready.
All right. Your Honor, we're complaining about the judge's decision in finding that there was insufficient evidence presented at summary judgment to have this case proceed to trial. It's a red light swearing match, one of the most common traffic incidents, probably behind the rear end. This had the benefit of being investigated by law enforcement, and a law enforcement officer went out to the scene. He inspected the physical evidence, he inspected the scene, interviewed the drivers, interviewed the pedestrian witnesses, and prepared a report that says, hey, Waco Transit, your bus had the red light, and I'm faulting you for that. Waco Transit wasn't happy with that and approached law enforcement with a video and said, this is from our dash cam. The video tells us that we had the green light. The officer looked at it, prepared a supplemental report, and said, yes, I have received this additional evidence. I have reviewed the evidence. The quality of the video is insufficient for me to make the call on who had the green light. And so I can't determine from this video that your person had the green light. My conclusion based on other evidence stands. Waco Transit took that gentleman's deposition. In his deposition, he testified consistent with his reports that Waco Transit, the bus, had the red light. Waco Transit wheeled in a large flat screen TV and placed it 3 or 4 feet away from this officer's nose and replayed the video for him and said, can't you see this is a green light? And he, after affirming that, yes, I have good vision and no, I am not colorblind, this does not show that the light was green. It simply doesn't provide any evidence to have me change my opinion. And we go through the process, the deposition with that. That's kind of where we are. Waco Transit is framing this case a little bit on the idea that the presence or absence of the green light for either driver is dispositive of the negligence cause of action. Not necessarily. There were comment cards that were produced that Waco Transit takes these cards and gives them to its passengers, and it's basically, rate us, how did we do? And they simply collected evidence about the crash. The passengers on the bus wrote that they were yelling to the bus driver to stop. There was danger. Some people saw it, immediately. Other people were responding to that. And, that's slightly different from having comment cards that tell us, I eyeballed the light and the light was green or the light was red. The negligence cause of action is broader than who has the legal right of way. Nearly 50 years ago, this court wrote extensively on this, the same fact pattern, and explained, following Supreme Court authority and following other circuits, that when a driver has the legal right of way, but there are visual things that would indicate to this driver, don't go near the intersection. That's identity of the oncoming car, first identify that it's there, making assumptions about speed, no sign of stopping, obvious driver inattention. And I'm referring to the case of Lawson versus the state of McDonald, 1975. It's writ refused NRE. And that holding, that language is repeated many times. And it's repeated for the idea that if there are visual signals that would clue in a driver to not proceed in the intersection, even with the legal right of way, the driver can, or nonetheless, proceeding into the intersection. Our case,
Council, I think that generally is considered like last clear chance. Or is it different than that?
it's different. I mean, because I don't use the word last clear chance because that has been, frowned upon at times. But it is with, and the Supreme Court authority is broader than the intersection. The Supreme Court authority is that you may have a legal right to proceed and do something, but when by doing so, you are knowingly undertaking a risk of harm to somebody else, that you have to meld those two, duties. Your duty and right to proceed is not unfettered.
Was this theory of negligence presented to the trial court?
The negligence, just a broad negligence claim was presented to the trial court. This case is very different though, because all the other cases that I've talked about that you can't gallop headlong into danger, deal with what you saw. And so it is you saw it and you simply decided to do it anyway. Here we have something different. Here we have all of these passengers who are, there's no indication they are CDM drivers or anything like this. They saw the danger and were yelling and alerting the driver to the danger. So that is a slightly different fact pattern.
I bet you when this is tried, if it's tried, it's going to be that they were distracting the driver instead of alerting the driver. But I digress.
It may well be. It may well be. I'm beyond being surprised at things. But
I wanted to actually pursue another question. I would take it from your introduction that you do not agree that if the video is sufficient to establish that the light facing the bus driver was green, that's not the end of the case. On that, the video, if the video evidence is undisputed that the light is green, you still don't think that the trial court could grant judgment to Waco Transit?
I think the trial court, in terms of after a jury trial or at summary judgment.
Summary judgment.
No, the trial court did not do that. The trial court did, and the background facts are fleshing out briefly. We know that from testimony that the oncoming pickup truck was traveling roughly 40 miles per hour. We don't know how fast the bus was going, but we have a video of the bus. And while it's not clear enough for us to see which light is illuminated and if it's red, it's green, anything like that, we do have a sense that this is a large bus making a 90-degree turn onto a road where there's limited ability to expand the radius by swinging wide. The bus was moving very slowly, truck moving very fast. So part of the doctrine of you're not completely exonerated by having a legal right of way is you have to have an opportunity to do something different. Many cases there's not. Here evidence tells us that there is. We have in the case several evidentiary objections to some of the evidence that we had 6, 5 and 6 are, I'm not complaining about those. 5 was the video itself. And at the time I was writing the brief, I actually thought that the video was in evidence, but the only thing that was in evidence was a photocopy of the DVD of the video. And the actual video was never put into the trial court's record. So that's moved. Number 6 deals with some employment direct negligent claims against Waco Transit. That is moved. I would like the court to review the first 4 objections. And normally, because the only role of the movement's evidence is to shift the burden of the, when we have a hybrid motion that starts with a no evidence where they don't have to produce evidence, the quality and admissibility of their evidence is only relevant to whether something is there to shift the burden to me. But that's probably a distinction without a difference because I'm responding anyway to the no evidence. Here is my concern. City of Keller versus Wilson talks in very broad terms that we want this to be the metric for measuring evidentiary sufficiency across all situations. Jury trial, bench trial, trial disposition, all of this. But it also opens up the idea, and it recognizes our traditional summary judgment standard that does the evidence presented at summary judgment enable or reasonable and fair-minded jurors to differ about the conclusion to be drawn from that evidence. And I'm trying, I guess, with all the evidence that was produced by my side, I have an adverse ruling, and I am concerned that if City of Keller has the mechanism that Supreme Court is using to allow a factual sufficiency review to kind of sweep under the legal sufficiency umbrella by stating that we'll disregard all contrary evidence unless a reasonable juror could not. And so that's why I'm concerned. I don't want to take a case on that point, that the non-movement's evidence to shift the burden should not be considered in measuring whether or not I have produced evidence as the non-movement get to trial. But City of Keller contemplates that may be the case. And so if that's the case, I would like to have my evidentiary objections ruled upon. I can talk about the specificity of them, but it's basically an expert. Is it hearsay? Is it proper for an expert to give testimony under the umbrella of being an expert on, I looked at it and the light looked green to me? Red versus green, that's not something that, experts need to be testifying about.
Which led to my initial question of whether or not, if the video is clear that it is green, does that end the case?
No, it's not in the case. The video being.
So why does it matter then what the standard for the review of the evidence is if we just take the video and set it to the side?
Okay. Because we have an expert report that says, I looked at the video and I determined the light's green. We have an expert report that says the light timing sequences suggest that the crash happened this way, but light timing sequences require light timing analysis. There is no data supporting this expert's opinion. I mean, an analytical gap supposes that we have a fact and then we have a conclusion and we measure the extent of the gap. But with the complete absence of the underlying facts, all we have is the conclusion. And that doesn't work on the light timing thing. Similar to the light timing thing, I mean, just to clarify for everybody in the room, this happened in the city of Beverly Hills. So we're talking about a small compact footprint. The police officer testified that he goes through this intersection several times a day. And his description of the way the light sequence works differs from the sequence that the expert assumed was at play. And the expert didn't address that. So we have an expert giving light timing opinions without light timing data, and that contradicts other evidence from authoritative sources that are contrary to his opinions, and those are not addressed. So taking out the weird City of Keller aspect of this, the burden never shifted to me officially on the additional motion because none of the evidence offered by Waco Transit was common. But I think that is a waste of time because I'm still going to respond to the no evidence. So I did on that. And again, for purpose of the video, it is indeed set aside because it's not in the summary judgment record. For those reasons, because we established bunch of evidence. I don't know when a scintilla becomes an avalanche, but in a red light dispute, we have an avalanche of evidence supporting Mr. Jordan. We believe the trial court erred in its decision. We request that this court conduct a de novo review of the entire record, reverse the case, and send it back down to the trial court for trial. And I yield back some time to the court unless there are questions.
I do have one question. So the trial court, in making the ruling on the motions for summary judgment, never viewed this video. The only way the video comes into play is because the expert viewed it. Is that, am I straight on all that, or correct me if I'm wrong?
That is my belief. With the clerk's office denying repeatedly receipt of the video, I cannot imagine the judge ever looking at it. The video was reviewed by the expert, and he relied on that as he entitled to in his report. But it was not part of the trial court's decision-making process.
And the judge looked at it simply because the expert had pulled that out a still shot of the video. Is that your understanding?
Yes, the report has screen captures. I think we may be seeing some of those today from the video, and those were pasted in the report. My hearsay objection to the report is still out there, but the judge is able to look at things, and see that.
Question? Okay. Thank you, counsel.
All right, thank you.
You may proceed with your 3 minutes when you're ready, counsel.
Thank you, Your Honor, and welcome this afternoon, Highlanders. Jordan's claim against Waco Transit is a claim that we refer to in the law as a vicarious liability claim. What that means is that he's suing Waco Transit for the negligence of its employer, bus driver named Bolden. So even though Bolden is not a party, in order for Jordan to get to trial, he has to show some evidence that Bolden, the bus driver, was negligent. You heard mention from my friend Mr. Samples about a direct negligence claim. There are some cases where you might separately sue the employer for their own negligence, and initially that was alleged, but later dropped. So all we have in this case is the question of whether Jordan raises in the trial court at this summary judgment hearing some evidence that the bus driver was negligent. It's my contention that the only negligence that Jordan is alleging and raising in the summary judgment response is that the light that the bus driver was facing, exiting the Veterans Administration Hospital, commencing a right turn on New Road. Jordan is saying that light that Bolden was facing is red. The video evidence that we are presenting demonstrates that it's green. Now, interestingly enough, Mr. Jordan testifies at his deposition that he had a green light. That really doesn't matter unless he shows that the lights are properly timed. Because you can technically have two parties with green lights and a collision caused by someone else, whoever's operating the intersection. But that's not his claim here. He's saying, I had a green light, so the bus driver must have had a red light. That doesn't always necessarily follow. So the question is, did he show evidence that the bus driver had a red light when he failed to yield the right of way while making a right turn on red? In our common law system, is juries who resolve disputes of fact. Judges, on the other hand, make legal determinations. They decide what law applies to the case. And sometimes that means they decide before trial, as Mr. Samples pointed out, is there even enough evidence for this case to go to a jury? If you don't have a factual dispute, you have nothing for our jury to resolve. And that's an important sort of gatekeeping role of the trial judge, because we want to make sure when we submit questions to the jury, they actually have evidence on both sides, a swearing match, if you will, where that's all there is. One party says, I saw you run a red light. and the other party says, no, I had a green light. That's the typical swearing match, and when you put 6 to 12 ordinary, unbiased citizens in the jury room, they have a real knack for figuring those things out. That's part of the essence of our justice system, that we trust our peers to decide those kinds of questions of fact. But as I said, there has to be a factual dispute. And here, our contention was that there was not. So Waco Transit filed what's called a motion for summary judgment, asking the judge to review the evidence and decide there's really nothing for a jury to decide. No reasonable juror could look at the video evidence and the still photos that are just screenshots, if you will, from that video, showing green lights facing Bolden, and determine that somehow he was negligent in making the right turn.
Counselor, when you need to wrap it up and talk to us.
I'll present my case to the court at this point. Thank you. Your Honor, it's my privilege to represent Waco Transit before the court today. Judge Meyer granted Waco Transit's traditional and no evidence motion for summary judgment without determining which part of the motion that he was deciding. 1 week later, Judge Meyer then signed an order overruling Jordan's 6 objections to the summary judgment evidence. We heard today, and I suspect that would be the case, objections 5 and 6 are no longer relevant. The appellant raises 3 issues on appeal. The first 2 are converse arguments, 2 sides of the same coin. That is, whether Waco Transit met its burden that it was entitled to judgment as a matter of law, or conversely, whether Jordan raised a fact issue in support of his argument that the bus driver ran a red light. Jordan's 3rd issue then complains about the trial court's rulings on the objections, and I anticipate getting to those as well. And
It seems our first dispute is what were the grounds of negligence? And that concerns me because I wasn't seeing that in the briefing. Would you address this argument of, well, it's not exactly the label he wants to use, but the last clear chance to avoid this accident being on the Waco Transit?
And Your Honor, I was surprised to hear that. So I was happy to be able to look at the record so I could cite directly to you the record. As the court knows, Rule 166A says that no ground that was not raised in the trial court is a ground for reversal on appeal. It has to be in the written response. So I would cite the court to the clerk's record, the 2nd volume, page 1172. That's where in Jordan's response to Waco Transit's summary judgment motion, the plaintiff addresses breach, and it's just on that 1 page. And what the plaintiff says is that Waco Transit had a duty not to run the red light. That's it. Then it has 2 sentences that say that there's evidence that people on the bus cried out that the light was red, it's running the red light. It turns out that's not in the evidence. And I want to talk about that both in terms of the evidence and alternative theories and objections. If you look at Officer Leather's report, he talked to people on the bus and outside the bus. And the suggestion that we hear is that there were people who saw the bus driver run a red light. Not a single person says that. And that's just a matter of the evidence is conclusory. It's not a hearsay objection. There's just nothing in the record on those courtesy cards or in Officer Leather's report where you can say that someone who spoke to the officer or turned in a courtesy card said, I saw the light and it was red. They either didn't see the light at all or they didn't say the light was red. What you have is people exclaiming when a crash is happening as it's occurring. And that might be the only hearsay on the video, but the video, when I play it, is silent. You can get the volume for a while, then you try to stop it, it goes away. So it doesn't seem to be helping. The focus for purposes of summary judgment is what does that video show? And what I'm asking the court to do is adopt what I'm calling the undisputed video evidence rule that the U.S. Supreme Court articulated in a case called Scott versus Harris and I'll provide a letter brief, but it's 5:50.
We're gonna come back to that.
Okay,
But the first question, the second issue that we seem to be needing to address is whether or not the video was even in evidence and whether or not it was viewed by the trial court.
no way to know whether it's you, Your Honor, because that's not in the record. It wouldn't be. That's what the judge takes up in chambers. This was a Zoom hearing. The record shows a notice of a Zoom hearing. Whether Judge Meyer
Okay,
actually.
let me back up then. Not whether or not it was viewed, but is the video in evidence available for his review and consideration?
Yes, in fact, I did have to go through some effort to make sure that CD that only shows up as a Xerox copy of the CD or DVD in the clerk's record actually was in the clerk's office. It was in the file and then eventually got sent up to the Court of Appeals. So the trial court had it at the summary judgment stage, and now this court has it at the appellate stage. Whether the court viewed it.
Okay, go back to the undisputed video evidence rule that you were citing.
Your Honor, in Scott versus Harris, and this is a fairly recent case, 2007, 550 US 372. Well, let me do this. I know I need to give a heads up to bring this screen down. We have a few people here. Let me talk about this case in the context of the photographs. And this relates to the expert testimony being necessary too. As long as you have Officer Leathers saying, I can't tell what the video shows. And when I look at the video, it moves quickly. The only way to really tell what the video shows is to stop it, freeze frame. And that's what the expert did. That's what I'm intending to show the court today. So the question is whether these photographs provide undisputed video evidence that the light is green. And then I'll talk about that in the context of Scott versus Harris.
Well, before we get there, let me ask another question. And that is, how do you respond to the fact that this expert report was actually not prepared for litigation?
The expert report was prepared for litigation.
Yeah, but was there an objection to it based on the fact?
The objection was that it was hearsay. My response to that is, yes, there is a business records affidavit paragraph at the end of Kazner's affidavit, but his testimony in the affidavit has to be supported, as Mr. Samples just pointed out, by underlying analysis, facts, and data. That's in the report. He incorporates by reference that report. And it's not hearsay, or even if it is, it's admissible because an expert is relying upon that.
You're relying on the fact that an expert can consider hearsay evidence in rendering his opinion. Okay.
And if there's even any hearsay in that, I don't know what hearsay specifically. The hearsay within hearsay is found in the report. He's articulated the things that he reviewed. He reviewed the dash cam video. He reviewed the freeze frame shots from the video. He reviewed the data from the light timing sequence. And the underlying evidence doesn't have to be before the court for the expert opinion to be admissible. The other side's entitled to ask for it, but didn't do that, and didn't lodge a methodology challenge in the trial court. So the only challenge that's properly before the court on the expert's opinion is it conclusory? So you have to look at the report to see that, no, it's not conclusory, because you can see what he did, the analysis that he performed, and the data that he relied upon. This whole page showing what he relied upon. So the first image I want to show the court, and this kind of leads up to what's actually helpful. This is just to set the scene. Figure 7 shows the northbound traffic on New Road, indicated by the red arrow on the right, stopped at the light, and that's important. Across the intersection, there are no vehicles staged in the left turn lane as marked by the green arrow. That's going to be important in response to Mr. Samples' argument about the officer Leathers saying, I'm familiar with this intersection, and the expert didn't understand. He actually did anticipate in the report the very thing Leathers talks about, and I'll get to that in a moment. So there are no cars staged in the left-hand turn lane where there's a green arrow, so there was no reason to keep that lane open to allow left-hand turn cars to proceed. As a result, there are times when other cars would proceed on the northbound lane is going to be 3, 4, 5, and 6, and that's a timing sequence issue with a pressure sensor in the ground. Jordan's vehicle can be seen approaching at the far left and marked by the orange arrow, very, very far left of this frame of the video. A second later, in figure 9 of the report, and by the way, this is in that new supplemental record that was filed on August 25th. It's labeled A1128. The original was 1128 in a black and white version. But figure 9, the northbound traffic remains at a stop as indicated by the red arrow, and the blue arrow notes a green light facing the bus. And of course, every display has its own resolution. That's no different though than in the old days when I developed 35mm film and went into the dark room to blow up the 8x10 photograph of the high school football team. I had to set the f-stop on the print. I had to do things to get the best quality. No one is accusing Kasner of doctoring the evidence in this case or penciling in a green light. Maybe you can't even see it on this one, but we'll get to another. So figure 11 shows the bus entering the intersection and commencing a right turn, still in the face of the green light, which now is clearly visible. And if the court looks at the video, remember the placement of the lights for those who are colorblind is important. So even if you can't tell it's green, but you can tell it's on the far right or the bottom, you know it's the green light. So here, though, you have a freeze frame identified by Kasner showing the light is green as the bus has already entered the intersection. And remember, there's no summary judgment response suggesting that, well, he should have seen the truck coming and stopped anyway. That is not a basis for reversal of the summary judgment because it's not in the response. That argument is simply not there. And then finally, figure 13 shows that Bold had the green light even at the moment of collision. Here you have the blue arrow pointing to the light on the side of the road, still showing green after the collision has occurred. And so here we have undisputed video evidence when captured by freeze frames by someone who knows how to do that. Because I tried and it was very difficult to stop it when you really wanted to stop it and then focus on it. Who has told Judge Meyer this light was green. So what does Scott versus Harris say? When opposing parties tell two different stories, one of which is blatantly contradicted by the record, so that no reasonable jury could believe it, a court should not adopt that version of the facts for purposes of ruling on a motion for summary judgment. So the question becomes, if we went to trial, what would the jury be doing? The jury's going to look at those pictures of a green light, and it's possible, you know, that the plaintiff alleges a new theory on remand, but it's not before this court today. But if that's all we're talking about, did Bolton have a green light or a red light? Did he err because he turned right on red without yielding the right of way to Jordan? The court would have to tell the jury, you can disregard that video if you believe some other evidence.
Counsel, if you could go back to your first photo, please. I just have a question. I have seen the overhead of the intersection and the orange arrow pointing. If I recall correctly from my days as a municipal judge, if you have entered the intersection on a yellow light, no matter how small a part of your car has entered the intersection, you're in the intersection legally. Am I correct?
I understand there's a difference based on municipalities, but that's the default.
I believe that's the general rule.
Yes.
What evidence do we have that either way that you can see from that photo as to whether or not that vehicle has actually entered into the intersection?
And I don't know that I'm competent to answer that question. Of course, the overhead was a Google Earth. That takes a different
I
time.
understand, but it shows, clearly shows what a stop line is. If I can understand why a car who is actually legally entered into the intersection could be facing a green light, is that a possibility? And is that in fact a question?
You mean am I hearing you correctly, that if Jordan had legally entered the intersection, he might have been facing red light when this was taken.
Correct.
That is, I don't know whether we have to go back and see where the vehicle was, but in this one, he's, I think, well, back beyond the intersection, because later we're gonna see.
Well, if I recall correctly, the stop line was somewhat back from that intersection on the overhead.
Oh, so that.
I
that may
may
be-
be mistaken. I thought the stop line was somewhat farther back.
But what Castor points out, and you can see this in the video, is that Jordan's vehicle overtakes the vehicle just to his left. It's slowing for a stop, and he is quickly. Beat a yellow light, red light, I don't know. The question is, does Bolton have a green light? That's the only thing that matters under the theories that are presented in response to the summary judgment argument. So if we go to
Counsel, do you have video?
do I have video on here? I do, and it's the format that I have not quite learned how to manipulate. It's not the typical format that you watch videos on that you download from the internet. And so I get started, but I actually to get it to this spot would take quite some time.
My concern in this is understanding what is in evidence. Because the video that we got from the clerk, I've probably watched it 30 times. And in the video, the moving video that we see, it is much more on the order of the close-ups as far as the quality than these.
And because it's moving, it's difficult.
It hadn't been everything to do with the movie. It has to do with the focus.
Okay.
Because do you have on your availability here, the blow up of figure 9?
I do have. Get that.
It'll be figure 10 in the expert report.
So, so this is
Okay, now if you'll look,
10 is right here.
if you look at 10, you see the minute, the second, and the PM at the top. That's what we see on the moving video.
Right.
If you look at figure 9, it is a much clearer image of the intersection of the whole scene taken from further back.
And whether that's something that Kastner had to adjust, is I had to adjust f-stops on a printer for 8x10 from a 35 millimeter negative, or whether that's something in the technology is not before the court. And so if Plaintiff wanted to challenge that, he had every right to challenge the expert opinion and admissibility of that evidence in that regard.
Don't worry about that because we need to talk for a while. What I'm trying to figure out is what was available for the trial court to,
So just Kastner's affidavit, his report, the video, and the report has these freeze frames from the video.
if you go to figure 9, it is not on the video that the court received.
You're not, and I take the court's point, the court can't see this image in watching the video. How did Kastner get to it? That's not in the record. But I think what we do is, in that situation, Judge Meyer had those 3 things before it. Plaintiff had every opportunity to object. Judge, you can't see figure 9 in that video. The methodology the expert used is not appropriate. That expert type of objection is not before the court. So Meyer's judgment should be affirmed because there's not a challenge to that aspect of the evidence. And we're back to the undisputed evidence issue. And what I'd like to do is provide just a letter brief with 2 cases I didn't get time to cite to from the Eastland Court of Appeals.
Well, tell me about it.
The Eastland Court of Appeals and the Beaumont Court of Appeals recently in Hadley versus Valeris, the Beaumont Court of Appeals, citing the Scott case, held that the trial court was correct to view the facts in light depicted by the video even though the deputy sheriff's dash cam showed something that was contrary to what the plaintiff was complaining about. And in Klassen versus Gaines County, the Eastland Court of Appeals, and that's another sovereign immunity type case, affirmed the dismissal and summary judgment in an excessive force claim against the sheriff's deputies because the video evidence blatantly contradicted the plaintiff's contention that the deputies threw him on the ground and jumped on his back. So the question is whether this video evidence with the freeze frames taken into account, we have expert testimony explaining I took these from the video. No one's challenged that. No one says he doctored it and colored it green. The question is whether we're going to apply that same rule to this case so that Jordan's testimony that he had a green light is no longer competent under the Havner case that Mr. Sample cited, and also under the Keller, Mr. Sample cited Keller, under Keller and under the Havner case. It talks about the 4 ways you affirm a summary judgment. The only competent evidence is what you see in the video, because something about Jordan's testimony is such that no reason to believe it when they see the green lights.
You made reference to the officer's modified or redone report. Where is that in the record? And then the courtesy cards, where are they?
So at the Applebee's brief, pages 21, 23, I go through everything that Mr. Jordan's summary judgment response cites to, and that's officer letters report, supplementary report, sometimes making reference to conversations that he had with witnesses, and sometimes making reference to
Where is that report in the
record. I'd have to look that up.
Okay, in your supplemental brief.
That's actually in the plaintiff's response rather than in anything that we put before the trial court.
Okay.
But I can get that to you as well.
Is that where the courtesy cards are as
Yes.
well? And did I understand you to say that positioning of the illuminated lights is important because a person that's colorblind can see which one, and what is the location of the red light?
Right. So, and I think that some courts have taken judicial notice of that in the past, but the green light's always on the right or the bottom. Red light's always on the left or the top. And occasionally you have things like turn lights and turn signals that there's a code for, but not that people aren't as familiar with those. With the red light, green light, they're standard across the country.
So the green is on the bottom
Yes,
or on the right?
on the right.
So in this figure 9,
And then, of course, that's not the best one, but as the bus makes that turn, then you can see in figure 11, the vertical light where the bottom light is green.
yeah, I want you to go back to 9.
Okay.
Because you're looking across the intersection and I'm not. I'm looking at what Mr. Jordan was looking at.
Mr. Oates has actually advanced to place the video where this is shown. You can show that if the court is interested in that. It does take a moment to get to this particular spot. There. Yeah, about 10 seconds.
I mean, the whole video, as I recall, was only 15 seconds. So
You show about 10, 15 seconds left.
is
The whole
there,
video is a lot longer than that. There actually were a couple of videos. Well, there were other cameras. So there, yeah, there. Yeah.
that's all right. Go ahead and wrap up your argument.
Your Honor, because the undisputed video evidence when the freeze frames that are authenticated by Mr. Kasner are taken into account show undisputedly that Mr. Golden had a green light. Waco Transit asked this court to affirm the summary judgment and to affirm the dismissal of Mr. Jordan's case. Thank you.
Thank you, Counsel. I'm sorry, judges, did y'all have any other questions? I'm sorry. I thought I had tired y'all out already, so.
We were trying back.
Hello again.
Proceed when ready. You may proceed when ready. Go ahead.
Thank you. Let's talk a little bit about the scope of the summary judgment grounds. At trial, the jury is not going to be asked to answer a question, was the light red, was the light green? The jury's going to be asked to decide negligence, and that was the ground. Our summary judgment response addressed squarely what was placed in the summary judgment. The effect of that was that summary judgment was granted potentially on one method of proving negligence, but not on the negligence cause of action. All of the energy from Waco Transit was dealing with the color of the lights. We've seen the video. When I talked to the clerk, they didn't have the video. The video that I've seen from Discovery was much longer than 15 seconds. So I don't have anything else to say about that. But talking about whether, I guess we do not know if the judge, of course, if he reviewed the video of the trial court, and it is certainly not established that it was available to him at the time he rendered his judgment, as opposed to being placed in the record later at the time. The mere fact that an expert relied on inadmissible evidence, hearsay, or whatever it was, he's entitled to do that. But that does not independently make that evidence admissible for us to open up and examine in the detail that people have done in this case. Her testimony about after the crash, we see a light that suggests that the bus driver's light was still green. I think the picture looks like it's green, but still green is very different. If looking at where Mr. Jordan's vehicle was at its speed, maybe he was, I agree, he was going at a faster rate of speed than a car adjacent to it. Was he trying to beat the light or something? I don't know. But evidence of the light that's facing the bus driver after the crash tells us nothing about what the bus driver had in front of him at the time he decided to proceed into the intersection. And it was, is undisputed video, Doctor, was that?
That's the term I made up.
Okay, and I like the term, it works, but it's not undisputed if we have the law enforcement officer reviewing it in his office, preparing a report specifically to address that fact, and says, this is not conclusive for me one way or the other. Then being examined on that in the deposition, and once again, watching the video during the deposition and reaching the same conclusions. In the deposition, there was discussion about and questions from Waco Transit about the positioning of the lights, whether it's traditionally the light that says stay away from the intersection is going to be on the left or at the top, and the green light go through. It's usually at the bottom, but sometimes it is near the bottom if there is an arrow there. When Officer Leathers, at the time of the deposition, he was a Deputy Leathers, was watching the video, he was questioned about that. And the video would not allow him to determine which light was illuminated. The video clip was that grainy. So there is nothing in the record outside of potentially some video that even tells us which light is illuminated. I want to step back. I've got a few seconds here. Just this court has held before very clearly that in a summary judgment proceeding, this court does not, upon review, does not weigh the evidence. And if we're going to look at the video and adopt something like a fairly well-named undisputed video, doctrine, that means this court has to decide that it is going to evaluate the movement's evidence in determining whether or not the non-movement has met its summary judgment burden. That is a shift in the law for this court, and I believe for Texas, and I would ask the court to reject that invitation. I've got my red light, so thank you. Request reversal on remand.
Red light.
Yep.
Thank you, Council. This case is submitted and y'all are excused. And the court stands adjourned. If anyone had a really burning question for the Q&A that didn't get to ask it after lunch, I will yes, or it has just come in. We'll entertain that. Hadn't really planned on it, so it wasn't announced, but anybody have a burning question? I'll take it by your silence. You don't, and we stand adjourned. Y'all are excused. Thank y'all very much for coming.
That's